talked in the last two videos about trademark registration, but here's a fun secret. You don't have to have a registration or even apply at the PTO in order to have trademark rights. As we've said before, trademark rights arise from use in commerce. Registration just records rights that already exist. It doesn't create them. So then what's the point? What's the point of going through this whole examination process and spending the time and the money to get a registration? I'm going to give you 11 good reasons today. So number one, it discourages others from using confusingly similar marks in the first place because it makes the marks easy to find when they search the trademark database. It's always good to prevent problems before they even start. Number two, it protects you against the registration of marks that are confusingly similar because the Trademark Office has a duty to investigate and to cite prior registrations against applications for confusingly similar marks and to refuse to register such marks. In this case, you've got the full power of the US government helping you to prevent infringement. Number three, it treats the mark as if it's used nationwide as of the application date. Without a registration, your rights are going to be limited to the geographic area where the mark is actually being used, which potentially allows someone else to use the same or a very similar mark in a different part of the country. Eventually, this is going to lead to confusion when either you or the other guy expands your business. I do have to admit here that there are some limitations to the ability of a registration to prevent uses in every single corner of the country if there's no use there, but a registration does give you prima facie evidence of the rights across the country, meaning that if the other side wants to say that you don't have rights, they're going to have to prove it. Number four, it gives you nationwide constructive notice of ownership of that mark as of the date of registration. What this means is that someone else can't claim that their later adoption of your mark or a similar mark was in good faith. Number five, it gives you a heightened level of protection after 5 years. We call this incontestability. And what this does is wipe out a lot of the defenses that someone might have in the case of an infringement lawsuit. It can help in court proceedings, but perhaps more importantly, it can help quickly convince someone else to stop using a mark like yours before we ever have to go to court. Number six, it gives you the right to use the circle R symbol when the mark is used for the goods and services listed in the registration. This gives your product marketing cachet, and it puts competitors on notice that you are serious about protecting your rights. Number seven, it grants you the right to sue in federal court, and in certain cases, it can give you the right to get triple damages and get your attorney's fees back. Number eight, it entitles you to certain statutory damages in the case of counterfeiting. What this means is that you don't have to prove your damages in order to get a money award, and has the added bonus of making litigation much less expensive. Number nine, it gives you a basis for a foreign registration as your product takes off and you expand around the globe. Number 10, it gives you the right to record your registration with the US Customs and Border Protection to block imports of counterfeit products, which gives you even more of the power of the US government to help protect you. And finally, number 11, if you ever go to sell your business, a buyer is going to do due diligence on your company. Registered trademarks can enhance the value of the business. Unregistered marks will have to be examined for validity, and they'll slow down the process of the sale. You can sell faster, and you can make more money. There are a lot of great reasons to register a trademark, and not so many not to. So if you're ready to get started, go ahead and give us a call. For now, thanks for watching. Bye.